This video is an overview of several basic considerations regarding genealogical research. Although superficially diverse, each of these considerations influence research methodology and impose restrictions on certain areas of research that should be considered as genealogical guidelines or rules of the road. These considerations include the effect of copyright law on research and publication, the need to provide sources for all the information gathered and incorporated in family trees, attribution for any ideas or concepts borrowed from others, why some genealogical records are restricted, especially those dealing with famous people, the effect of the privacy of living people on the availability of records, and lastly, the 110-year rule as it applies to temple ordinances performed by members of the Church of Jesus Christ of Latter-day Saints. In each of these areas, the explanation is short and concise. First, we have the challenge of copyright law. Overall, copyright law around the world is a highly complex subject. Copyright is a type of intellectual property that protects original works of authorship as soon as an author fixes the work in a tangible form of expression. Quoting from the U.S. Copyright Office, as a general matter, copyright infringement occurs when a copyrighted work is reproduced, distributed, performed, publicly displayed, or made into a derivative work without the permission of the copyright owner. However, as copyright claims apply to genealogical research and records in the United States, there are only a few things you need to know. A work of authorship is in the public domain if it is no longer under copyright protection or if it failed to meet the requirements for copyright protection. Works in the public domain may be freely used without the permission of the former copyright owner. In the United States, records published before 1927, with or without a copyright restriction, are in the public domain. This date changes each year that passes, so in 2023, the date will be 1928. The laws regarding copyright protection change from country to country. Works prepared by an officer or employee of the United States government as part of that person's official duties are not protected by copyright law. After 1989, with the application of the Berne Convention, an international agreement, there is no notice requirement for claim of copyright. That means virtually everything published or every work is covered by copyright. If your child draws on a piece of paper, the drawing is covered by copyright. You need to be very cautious about using any publication, work, photo, drawing, anything that is not specifically in the public domain or free to use. Quoting limited parts of a work covered by copyright for research or educational purposes does not violate copyright law, and in the United States is covered by the complex doctrine of fair use. However, copying and publishing an entire copy of a work is not an exception and is not covered by the fair use doctrine. Many other records and publications are not covered by any copyright law in the United States, but the details of the expiration of the copyright is subject to a complex list of dates and situations. A basic summary of the law is available from the Cornell University Library in a publication entitled Copyright Services, Copyright Term, and the Public Domain. Changing subjects, when we build a family tree, we need to find a record that supports every event, especially any conclusions about parent-child relationships. We also need to record where we found the information. Genealogists refer to this as adding a source for every event. Most genealogy programs, such as FamilySearch.org, have a way to record the sources for each event in an ancestor's life. Information in any family tree that is unsupported by a specific historical source must be considered as unreliable. In addition to citing all our sources, When we use an idea or concept that is borrowed from another person, we need to give credit to the work of the person or publication where the information originated. This is called attribution and is an important practice for academic-based research. It is also a common courtesy. Ideas are not covered by copyright law, but failure to attribute an original idea to the originator of the idea seriously affects the validity of any research. Failure to provide attribution is commonly called plagiarism. As you continue to do research, you may encounter records that are restricted. Records can be restricted for a variety of reasons, including governmental, political, social, religious, and cultural reasons. For example, in Iceland, a huge historic genealogical database of the entire Icelandic population can only be accessed by those who are currently citizens of the country. Genealogists may want to become aware of the access restrictions of any records they are trying to research. If you haven't yet run into record restrictions in your own research, rest assured that if you continue to do research, you will. Some records may be restricted to viewing in a particular repository. As an example, on FamilySearch.org Family Tree, some collections of historical records are restricted as to where they may be viewed, such as a requirement to view them in a family history center. Some records about specific people, especially famous people, may be restricted because of claims of ownership. On the FamilySearch.org Family Tree, some individuals' records are restricted because they may be subject to inappropriate changes and attacks. In a real sense, any record that can be viewed in a specific repository or after payment of a fee or in any other way limited to viewing is restricted, and the genealogical researcher needs to observe and accommodate the restrictions. Privacy is a difficult issue, especially with the pervasive content of the Internet. People share publicly online many details about their lives that would have been unheard of before social networking. What information is or is not private is defined by cultural and social tradition, and seldom has been incorporated or codified into law, and is highly personal in nature. When talking about privacy, we all must remember that dead people do not have any privacy rights. Generally speaking, privacy has only become a major issue with the advent of computers and the Internet. In the United States, the most commonly encountered privacy issue is the Health Insurance Portability and Accountability Act, or HIPAA, H-I-P-A-A, relating to the disclosure of medical information. Otherwise, many things that you might think are private are not protected by any particular or codified law. So how does privacy affect genealogical research? The answer to this question depends on the country and the culture of the research. Most countries limit access to more recent records. This protection or limitation of access is partially motivated by income derived from the sale of copies of more recent documents. Charging for copies of records can also be based on copyright claims. For example, England owns the copyright to all its governmental works. The best rule about privacy is that if you do not want something generally known, don't put it online, and avoid publication online or otherwise of specific information about living people. Let other people publish their own life's details on social media. However, many families have family secrets, usually involving criminal activity or children born out of wedlock, and so there may be areas that are best left alone until all the concerned parties are no longer around to object. But remember again, there are no laws prohibiting using historical information about dead people for general use and publication, but it is wise to consider how publishing some information about a dead person may affect those who are still living. One other issue is applied by Family Search to members of the Church of Jesus Christ of Latter-day Saints, and limits the performance of proxy temple ordinances to people who are directly related to the deceased. The rule is known as the 110-year rule and prohibits anyone from reserving names for people born less than 110 years ago without written permission from a close family member. This is not a privacy concern, but arises out of a desire to allow those closely related to the deceased to perform the temple ordinances for their own family members. When the 110-year limit has passed, anyone can do the temple ordinances. For the year 2023, for example, this means anyone born before 1913 or in 1912 and beyond is not subject to the restriction. This rule is incorporated into the FamilySearch.org Family Tree Program, and those who are not involved in the temples of the Church of Jesus Christ of Latter-day Saints will not encounter this restriction at all. These short summaries may raise many questions. You may wish to seek additional information about any one or all the topics covered. Some of these topics, such as copyright law, are so complex that resolution of some claims of invasion of copyright may only be settled in court. Other topics may be something you need to automatically incorporate in your research activities and methodology. In the case of violation of any country's copyright law, it is important to seek competent legal advice from a person who specializes in intellectual property law. The other areas of concern that may be raised in this video are usually resolved by conferring with other genealogists who have more experience. Most of the decisions about what is and what is not properly conducted research must be determined by the individual researcher. Some topics, such as privacy, are so personal that you may find that everyone has their own opinion. However, other considerations, such as whether or not to add a source citation to every event in a family tree, are not subject to personal opinion. Please feel free to contact the BYU Family History Library if you have a need to discuss any of the topics in this short video.